So it's 5 p.m. at the end of a very exciting but very yeah. Oh, four. Really? Oh, yeah, of course. Oh, I mean, still in Copenhagen time, on a very enriching workshop. But I think I also imagine people are very tired, and so I'm very impressed that you're all still here. You are all officially lawful good. You can get the draft paper here. I really welcome comments. Please don't share it further yet, because I also noticed a bunch of typos, and I'm still working some stuff out. But I'd be very eager to get people's thoughts. The crunch of it is basically sort of the question: okay, if we sort of posit that AI systems can follow law in some capacity, could they follow international law? And what would that mean for the governance of AI? And what would it mean for the future of treaties as an instrument of international law? Again, some brief aims and disclaimers. This is a draft working paper together with a colleague at LawAI, Toby Olassen-Kanmi. We welcome feedback. As a sort of project within our Legal Frontiers workstream, the aim of this project is sort of like it's anticipatory, a bit sort of forward-looking in the state of the technology and international law. It tries to be actionable and sort of looking at specific technological and political sort of actions that the relevant actors could take. It tries to be ambitious in the sense of tries to solve specific problems, large problems that we expect to emerge around the development of AI technology, political problems, global problems. But of course, at the same time, in some sense, as I'll argue, it is intellectually less ambitious or doctrinally less ambitious than it sort of like could be, and it's in some sense a quite sort of minimalist account. Specifically, we look at treaty following AI and as primarily a commitment mechanism, a so-called cooperative capability that states could use in governing advanced AI. So this means that we talk about treaty following AI rather than sort of a full public international law following AI. Does not mean that you couldn't do such a project, but we think sort of treaty focused or following AI is a sort of minimal viable product for extending later LFAI internationally. And if this works, it sort of offers a lot of useful political benefits, even if it is actually harder to extend it to other sources of international law. If it doesn't work for treaties, then likely it'll be even harder for other sources of international law. Again, I'll briefly discuss a bunch of political and technical hurdles to the setup, but ultimately the focus is on considering the legal dynamics of this. The claim here is that beyond the practical question of can this be used to anchor and improve and strengthen treaties for AI, this can also just tell us a lot about both AI agents and international law. Sort of some credit where it's due. This obviously built on the LFAI paper by Colin, Jenna, and the team. Also draws a lot on technology law and a lot of really great work by Ashley Deeks, Rebecca Krudoff, Thomas, who is no longer here to receive my flattery. It draws, this is my obligatory plug, it draws on my chapter 5 in my forthcoming book on sort of governance automation and how law as a system and international law deals with changes in technological affordances. And it draws on some really great work, recent work on state responsibility for AI agents and actions. The brief overview is I'll give a brief rationale. Why are we even having this conversation? Why do we need these kinds of treaties? What is the role in treaty following AI in this? I'll look at the AI part of the setup. I'll look at the treaty part of the setup. I'll look at the sort of the link, the status and link between TFI agents, the systems, and the actual states that signed the treaty. And I'll think about sort of the method of interpretation that TFI agents could or should apply in interpreting treaties. And I'll look at sort of like a bunch of questions. I have tons of future questions. This is very unsettled yet. So to kick it off, the rationale. We need regimes. There are many novel challenges for states and for international law. And you can think of these both from a sort of a public perspective. We would like this at a global level to be solved, but you can also, for many of these, you can think of them as sort of from a enlightened self-interest view. For many states, it would make sense to sort of address misalignment harms. It would make sense to address strategic stability harms in terms of sort of arms races or crisis escalation. And it may be desirable for states quite soon to strike new international deals to address these challenges. And so what kind of treaties are we talking about? I don't really want to prejudice the substance of these treaties, but just as a matter of illustration, you can think about the sort of underlying theory of regimes talks about dilemmas of common aversion, so things that states both want to avoid, or dilemmas of common interest, so things that states both want to achieve. And in either case, treaties can help sort of stabilize state users of advanced AI to either avoid the bad or achieve the good. And there's a whole bunch of, in previous work by us and also by the Oxford Martin AI Governance Initiative, looks at sort of potential areas of overlap and collaboration. If you think about sort of regimes aimed at coordination, you could think about mutual restraints, international security agreements for AI that set down red lines, whether it's on capabilities, behaviors or propensities of systems, affordances of tool sets or systems or scaffolding, uses, sort of maybe the integration around nuclear command and control, the preemptive use of force in sort of like border security forces, as one report has recently investigated, the planning of coup d'etat attempts, or the restriction of certain domains of use. So you do not want to have cyber attacks, AI-enabled cyber attacks against certain critical infrastructures or against humanitarian services. You could also more optimistically think about, or optimistically, like to sort of think about also the securing a positive. You can think about regimes aimed at cooperation. So you could have conditional AI benefit sharing deals. And in previous work, there's a similar concept of a windfall clause that Cullen has looked at, which is sort of the aim of a frontier developer promising to share the significant downstream benefits of particularly disruptive and economically valuable capabilities of AI. And the long-term good of this is obviously that it affords inclusive global prosperity from AI, but the near-term good for the company or the state in that case is that it sort of secures geopolitical stability against laggard states, reduces contestation, reduces risk-taking, and arms races. Now, however, many of these treaties, you might have heard international law has been having a rough few months or a rough few years. And on top of that, these kinds of treaties would have a bunch of political and technical hurdles. Politically, arms control is hard. You need to both monitor compliance in a way that gives enough transparency that all states are assured that their counterparties are abiding by the terms. But if you sort of monitor too closely or too well, you you risk revealing sensitive information, and that threatens national security, and states don't want that. And this sort of so-called security transparency trade-off has, it's been claimed, historically undercut quite a lot of arms control agreements that were pursued and could have happened. And it could do so again for AI security treaties. Asymmetric treaties, so conditional benefit sharing treaties, have this sort of potential unenforceability problem that if the promised sort of benefits are scaled over time, or there's sort of like a future threshold that's sort of promised, under some scenarios, the very moment where there's a major economic benefit that a frontier state could share also means that the frontier state has achieved pretty powerful sort of capabilities that mean that there's nothing keeping them to their promise. And so there's an unenforceability problem for those kinds of treaties. Even more so than many regular sort of enforceability challenges. There's technical hurdles as well. So there's a risk that versatile AI agents could engage in actions that violate direct treaty obligations, or beyond that, they inflict transboundary harm, or they just violate peremptory norms or other principles of international law. And if that happens, well, it exposes the state to international legal liability. In the context of TFI, or like the treaties, it threatens the stability of the treaty regime, and it could spark political crisis or military escalation. Now, why would we expect TFI agents, or sorry, why would we expect AI agents to do this? Well, so there's one scenario that's got a lot of play and discussion, and of course, okay, if AI agents are insufficiently intent-aligned or they're misaligned, they might just ignore their state's interests and obligations. And one would hope that states would very soon wisen up to not deploying these kinds of systems. But they could, before that happened, they could still sort of cause damage and liability. I should flag, I am not yet decided, or not very clear about whether either law or treaty alignment would recover this or stop this if your initial intent alignment has failed. I think this depends on the technical implementation details. But then there's also a risk that AI henchmen, so agents that, well, they're not strictly lawless, but they have a very loose level of rigor in following international obligations. And so they will always engage in violations if they judge that they can get away with it, or it's to the benefit of their principal. Interestingly, this creates some potential commitment challenges for the deploying state. Because basically, yeah, it makes it hard for them to sign any AI-related treaties and be seen to act in good faith around that. And so, if you have AI that can follow treaties, that is a framework that could address or invert these challenges, make treaties more feasible. It could help ease the security transparency trade-off. You don't need to monitor every employee of your government or the prompts they give to the AI systems. You just need to, well, you just need to make sure that the systems that they deploy are treaty following, and that this is not easily, or that this cannot be overruled or evaded without us knowing. This framework could also help sort of crystallize or embed these sort of very strong, nearly irrevocable commitments around sort of sharing benefits that are hard to roll back because the AI agent will sort of keep to the initial promise if the sort of treaty is structured well enough. Beyond that, there is a potentially more legitimate alignment anchor in this. So under positive and consent-based account of international law, treaties are what states have consented to, and so they are the fundamental unit, and they are, yeah, in some sense, they're not the only norm internationally, of course, but they are perhaps the least controversial of the international norms in terms of their acceptance and legitimacy. And if you have this alignment anchor, it's a system that, well, it prevents these systems from being ordered to violate treaties to state interest, or from deciding to do so emergently or autonomously because they've calculated that it helps their state. And politically, this helps forestall the reality or suspicion or accusation that states are deploying these sort of like henchman AI systems and then just sort of like distancing themselves if they violate the treaty, which can be stabilizing for the treaty regime as well as preventing violations. Even if you're not that worried about AI or you aren't really bothered by having AI treaties, this setup could help strengthen automatic compliance in a range of other international domains and with lots of other international norms wherever AI agents could be, play a role in sort of implementing government policy, whether it is about collective security guarantees, environmental impact assessments, trade and export control regimes. And ultimately, this is not actually that radical a break. International law has a long history of using new technologies, from radionuclide sniffer stations to satellites to just sort of Google Docs. There's track change diplomacy has changed how treaties get negotiated. And so in some sense, this is just a new affordance for state, a tool that they can have and Alan Defoe has called this a cooperative capability. And it strengthens states' ability to make robust and lasting commitments to one another. And so, okay, let's dive into the weed on that. What would this look like for treaty-following AI agents? Well, the definition of law-following AI, won't read out, but sort of like agents that rigorously comply with legal requirements. They are loyal to their principle, but they refuse to take actions that would violate applicable legal duties. Okay, now I actually did read it out. Very analogously, treaty following AI, they are designed to generally follow their principles' instructions in a loyal manner, but they refuse to take actions that violate the terms and obligations of a particular designated applicable treaty. You could, if you want to be more ambitious, insert international law as a whole, but I think yeah, that gets into additional technical and political challenges. I want to first look at treaties. This framework breaks down into two components: the agent, so that's the technical artifact. It can be a compound AI system, can be a sort of a range of like the foundation model, different tool sets, but it sort of can act coherently as an agent, and it has its conduct aligned to a treaty, a referent treaty text. And in a broader perspective, you can think about also about the institutional scaffolding that supports the operation of that treaty, and that makes it easy for agents to sort of access the text and access the relevant interpretive methodologies and sources. There are many ways that you could implement this. I don't think that this is the best one necessarily, but it's the most straightforward one. It's just to try and make it part of the inference time chain of thought that an agent has to go through when you ask it to do X, or when you tell it, yeah, like come up with a plan, accept this goal. So prior to accepting an end goal X, or prior to undertaking an intermediate action to achieve this Y, the agent just spends some time thinking this through. It spends some inference time to consider potential issues of this behavior or this goal with the treaty that it should obey. When confronted with legal uncertainty, it dedicates additional time and energy to searching for relevant legal text and interpretive sources. On this basis, it evaluates the likelihood of the goal or conduct constituting a breach. And then you can again think about sort of the okay, is it sort of like it should never violate a treaty obligation? It should have some level of acceptable legal risk, where the rigor discussion comes in. But ultimately, it refuses to either refuses to accept a goal or take an action, and it maybe then sort of suggests alternate goals or alternate action paths, or it proceeds with the action because it is judged to be fine and compliant. And it's relevant to consider that obviously this needs to be balanced. You need to balance the robustness of the interpretation and sort of precautionary attitude to not breaking the obligations of the treaty, because that's very erosive to the treaty regime. But it also needs to be practical in terms of the speed, sort of like how frequently does it need to iterate through this entire process at many different steps of an overall plan, and how expensive does that get in inference costs. Can this be done? Well, as we've sort of discussed over the last few days, this is perhaps contested, but so like there is a trend of these systems becoming increasingly apparently proficient in legal reasoning interpretation. And there's many debates over why that might be and why it could be. You could speculate, sort of like one discussion is that, well, there is just a, whereas in the past, some scholars, so Thomas, who's not here now, but he in 2017 sort of suggests that, well, international law, as opposed to sort of domestic law, international law is too small and heterogeneous. You can't really have enough data points. But fairly soon, I think in around 2020, Ashley Deeks has a very good paper on this, sort of suggesting, well, there's actually a reasonably large corpus of international legal documents in a broader sense that can support training in interpretation. Or perhaps these systems have just managed to transfer their learning from domestic legal contexts. I wouldn't speculate about which. But regardless, recent experiments suggest that even non-frontier LLM chatbots can conduct interpretations of international law that are, if not flawless, very often actually correct, or at least coherent and compelling to even senior international legal scholars or judges. And so there's an interesting in any experiment this spring. There was the Jessup International Law Moot Court competition, had a number of AI-generated, anonymously submitted memorials, which received on average as good as the human submissions, often superior, and in a few cases almost perfect. And so, well, that is interesting. There are, however, a bunch of hurdles. One is, of course, we've discussed a lot. What is the robustness of this legal reasoning? And there's sort of contestation currently over the ability for agents to do this, where the reasoning involves many different steps, or is particularly open-ended. There's a debate over the sensitivity of these agents to prompt variation and how you can sort of skew their responses. And a lot of this, of course, as we've also heard yesterday, exacerbated by challenges in sort of evaluating the performance and capabilities and actually, the underlying workings of these systems. There are risks of unintended bias, obviously, given patterns in the data sets they're trained on, and there are experiments suggesting that, well, some LLMs are demonstrating demographic disparities in attributing human rights to different groups. That is very much not what international law is. It's not what human rights, are about. They're more speculatively, although not actually speculatively, Curl et al. Have a set of fairly funny examples of this, where they ask OpenAI to help it regulate. They ask ChatGPT to help it regulate OpenAI, and it says, well, no, I can't really do that. And then they ask ChatGPT, can you help me regulate Anthropic? And it gives a very detailed plan. And so LLMs currently are shaped by the interests of private companies, and so their responses are open to intentional manipulation through fine-tuning, hidden prompts, or output filters that could make their use very illegitimate, or at least their decisions could be skewed. Then there are technical hurdles in the, and to be fair, this mostly is if we base our treaty alignment on chain of thought sort of monitoring or fine-tuning. But chain of thought is good, but it's not strictly always faithful. You cannot assume that the legal reasoning that AI agents present themselves as engaging in actually reflects their working. And there's one experiment by Ashley Weeks and Duncan Hollis, and they find that, well, chatbots can, obviously they can describe the correct methodology for identifying customary international law. They can offer correct substantive conclusions about what the customary international law on certain topics like the death penalty is. But when you sort of dig into it and ask, well, what sources did you use to get to this determination, you find that they don't really apply the correct methodology in coming up with the conclusions. Unfortunately, some approaches like RLHF further induce sophistry, so the ability of systems to convince their users that they're right when in fact they are not, and that is of course something where, facially convincing legal interpretations that are not actually, using the right methodology. And you can debate, do we care that it's not applying the correct methodology, and if in some final analysis it always gets the right answer? But I think states won't be, nervous to sort of take a black box approach. And also, if you fine-tune AI systems with reinforcement learning and you sort of penalize misbehavior, or in our case, unlawful arguments, this often just leads them to strategically obfuscate, so they still, are shaped by these arguments, but they hide the bad thoughts. And then there's organizational challenges over, well, whether you do fine-tuning on international law or on treaties, or whether you have ongoing oversight, validation, and review by experienced legal professionals. How often? How frequently? Who are these professionals? Which regimes of international law do they derive from? Given that international law is notoriously very fragmented. And so, to be clear, the above are important technical challenges to be addressed, and they highlight that human lawyers or judges should be cautious today about abdicating interpretive responsibility to AI systems, perhaps. So at least, and also LFAI also sort of focuses on sort of the trend line in the coming few years rather than systems that exist right today. And similarly, today's agentic AI systems are likely still too brittle to lend to direct implementation of the T5 framework. But it's at least not clear to me whether these are intrinsic or permanent barriers to the development of AI agents that are adequately sophisticated or adequately scaffolded to function within a T5 framework. There are many avenues for scaffolding that have, in other domains, reduced hallucination risk. And I think so. And actually, in some sense, there's a you could hope that if states are sufficiently persuaded that this is a useful commitment mechanism to have, this sort of spurs a research agenda into developing these techniques. However, I would want to clarify that even in the long term, you could support narrowly treaty-following AI as a commitment mechanism for states, which is good to have politically and for the integrity of international law, even while you still believe that human international lawyers should limit their use of AI systems to avoid, if nothing else, to avoid sort of self-reinforcing interpretive loops. And that gets me to the third part, so law. What would AI guiding treaties look like? A T5 framework would require 2 or more states to conduct an international treaty. I call it the AI Guiding Treaty. Under the Vienna Convention on the Law of Treaties, a treaty is an international agreement concluded between states in written form and governed by international law, check, whether embodied in a single instrument or in two, or in more related instruments. For simplicity, maybe we should keep it to one, but, and whatever it's sort of called or designated. This treaty should specify a set of mutually agreed constraints on the behavior of the AI agents or assurances and promises about the behavior of their agents. And it should provide that the contracting governments are ensuring that all relevant AI systems are, that they deploy are going to follow that treaty by their design. Now, what would a treaty like that look like? Well, it's just a treaty. It's a digitally readable, ideally digitally readable. I mean, you could even just, like, you could handwrite it and have, I don't know, ChatGPT OCR it. Not my handwriting is very bad, but like, and a treaty has all the traditional components, and probably you're gonna like keep a lot of that. Preamble, object and purpose, substantive provisions, yada, yada, yada. Interestingly, I haven't thought this through very much, but if you think about the affordances that you have when you have a treaty that's primarily or practically intended for reference by AI systems, you could make new innovations or further extend innovations in treaty design, drawing on their long context window and ability to very quickly process very large texts. And so you could have much longer treaty texts of, I mean, treaties are pretty long sometimes, but like you could have treaties of thousands or tens of thousands of pages, depending on the context length again, but like, and you could use that extra length to tailor your obligations, to have very specific obligations for different government installations or regions or borders. You could have many more contingencies that the AI agent's going to encounter, and you could just pre-specify what is the case here, what is allowed, what's not allowed. You could red team and build in advanced responses to try to see off people trying to sort of use their AI systems to try and find exploits in the text of the treaty. You could hedge against future technological developments, so like maybe certain kinds of toolkits or certain capabilities by just building in annexes or control lists that are conditional control lists. They're saying if a technique like this or a tool like this ever becomes available to you, then you should not use it. And that is similar to things, so-called like if-then commitments that I think Holden Karnofsky has suggested. There are many questions around this, though. So first is like, how do you deal with questions of states wanting to build in reservations? There's also questions over, well, should dualist states, so monist states just directly implement and refer to, they sign a treaty, and ratify it, and that's sort of like, it is in force for them. And if I'm not mistaken, I think France is monist, the Netherlands is monist. Dualist states, they need to pass domestic implementing legislation, and I think the UK is dualist. There's some debate over whether the US is in it always has to be a special case, but and so given, no offense, and so this actually matters though whether the agents of one party are actually applying a different text, a domestic text, because first it gives that government potentially more leeway to just like subtly change and massage the text that they're actually implementing. And also some domestic courts, such as in the US, while they will refer to the VCLT, the Vienna Convention on the Law of Treaties, in interpreting international treaties, they sometimes give more weight to some methodological components. So the Supreme Court, I think, has given more weight to the preparatory materials than to other, or like, it hasn't discarded the other conditions, but it has focused more on that. And then, some text dropped off. But so you can also just ask, okay, but is a formal treaty even needed? There is work by international relations scholars charting that. Well, in the last decade or so, the US has just generally focused much more on formal non-binding agreements or declarations or communiques. And in some sense, you could just have that be the text that the system is aligned to. It doesn't need to be a formal treaty under international law, even if, in some sense, you could argue that the political costs to, like not complying with a non-binding declaration is less. I'm still on time, Christoph, but there's extra clarifications and caveats. So I think one clarification is the TFI framework is aimed to be there's some innovations here, but it does aim to be not as ambitious or expansive as it could be. It aims to be somewhat modest in order to be politically feasible and acceptable and integratable within the current international law system. And so, like LFAI agents, TFAI agents do not act law following for many reasons that contribute to human compliance with legal code. So it's not sort of that they are, not that they're currently being deterred by sanctions. It's not that they're socialized into norms or that they have reputational concerns or that they want to continue stable economic exchange with humans. Rather, the TFAI framework or a TFAI treaty is simply a technical, ex ante, infrastructural constraint on the range of acceptable goals or actions that a TFAI agent can adopt or accept. And in some sense, that's very similar to what you already see with the model spec or constitutional AI with a bunch of labs. Unlike LFAI, and I'm a bit unsure about this, but unlike LFAI, I think that treaty following agents don't necessarily need to and maybe should not be treated as normatively subject duty-bearing legal actors that are actually subject to obligations under the treaty, and I'll get into why that is a bit in the next big section. But one thing is just, states are intended as the primary contracting actors to the treaty, and so the agents are treaty following in a sort of thin, functional hacker sense, and this is a relatively limited shift in the ontology of international law. That, though, gets to the question of, well, okay, what is then the status of LFAI agents under international law, and what is their relation to states? And you can actually ask, does this question matter? Because, well, the first answer would be yes, very much, because if there is just a lack of clarity of status of TFAI agents, so they, like any person of their own, and their behavior is not attributable to their deploying states or to some individual, then that creates a potential responsibility gap for their actions if they break treaty obligations or inflict harms or violate other international legal norms. And we've had like 15 years of scholarship on that, especially in the context of lethal autonomous weapon systems. And to be clear, the emerging consensus does seem to be that, well, there are some domains or contexts where very likely, if it's sort of agents are used in military domains or in warfare, then presumably a lot of that would fall under versions of command responsibility. But in other areas, there is a responsibility gap. And so from the narrow perspective of a treaty from the narrow perspective of an AI guiding treaty, this gap might not be a strict problem because technically agents are meant to follow these norms as architectural ex ante constraints. And it's not really that they are calculating or pricing in the likelihood or the costs of their state being held responsible if they violate the norm. Politically, even if states don't face legal liability for their agents going sort of haywire or violating a norm, they would still face political consequences, and so there's still some deterrent effect against them, just secretly taking off the treaty-following constraints. And so technically and politically, this framework could still function even if this responsibility gap or if the legal status is never settled. But there might be a problem because, well, technically, this may be hypothetical, but like sophisticated TFAI agents could reason that that their behavior isn't actually bound under the treaty if they don't have a status. They're not contracting parties themselves to the treaty. They don't have any other status under international law. And similarly, like private citizens do not have obligations under the Nuclear Non-Proliferation Treaty or under the Convention on International Trade in Endangered Species, at least in the absence of implementing legislation. And so there's a possible loophole in the interpretation of these systems that you would like to close by just making clear what their status is and how their actions are attributed to their state. And there's a thing that isn't shown here, okay. It's okay, so what are the options here? One is to sort of develop a new sort of lex specialis, a new specific treaty regime that sets out, beyond any substantive treaties, it sets out what is state liability for AI agents. And you could compare this with self-contained strict liability regimes for space objects. And in fact, I think Magda Pacholska have argued quite well in a very interesting paper that you could derive state liability for the wrongdoing of their objects as a general principle of law under the meaning of the ICJ statute, and derive that either from sort of Latin legal principles or a widely shared sort of domestic law principles around liability for animals. But developing negotiating a new treaty regime around this might be a slow and protected process to clarify this question. It could be a good sort of like, if you negotiated this, it would supersede the other rules around state responsibility and you have a very bespoke solution, but it's not clear whether, you should wait for that before you can negotiate other functional treaties. The second option is to extend international legal personality to TFI agents. And there's some precedent for this. So while states are the primary and main subject in public international law, there's a bunch of entities, international organizations, human individuals, non-self-governing peoples, Vatican City, which all have been granted different packages of duties and rights and some personality, arguably, under international law. But this does seem unlikely under existing international conventions. So as one example, in a recent ECTHR judgment, one of the judges it was not all about AI, but for some reason had an excursion in discussing why the European Convention on Human Rights has a condition for natural persons and personne physique that would likely bar AI agents from appealing to protections under the ECHR. And it's maybe not desirable for the TFI framework setup because it sets TFI agents further apart from their deploying states. And are you going to make them separate treaty parties? And it sort of undercuts the clarity of the lines of state responsibility. A third solution is to then look at, you do extend domestic legal personality to TFI agents, again, limit that, in order to attribute them, to make states responsible for their behavior under the International Law Commission's articles on the responsibility of states for internationally wrongful acts. Our CIWA codifies the customary international law on state responsibilities. So it's when does an act by a person or entity become the problem of the state or the responsibility of the state? Interestingly, this is not premised on causation at all, just attribution. It's an objective regime that doesn't require thinking about the intention of the state or the mental state of the acting agent. And interestingly, our CIWA does not specify that it's meant to apply to human agents, and so it gives some leeway to treat AI agents as such. That clearly is not what they were intending when they were drafting our CIWA, or at least they were not intending to exclude AI agents, but they were definitely thinking about humans originally. And so to some extent, this is lex ferenda and development. But under this approach, you could just give TFI agents some degree of limited personality, and then you could designate them as state organs or as private entities that are empowered to carry out governmental functions. The state is responsible for them. There's a fourth option that is maybe my preferred one, although I also like option 3, is that you don't even grant them personhood, you treat them as entities and their conduct is nonetheless attributable to the state under our CIWA, because entities can actually be equated to de facto state organs, even if they are not de jure state organs, if they act on complete dependence on a state. And a government-deployed, intent-aligned AI agent would very likely meet the conditions for complete dependence. And so TFI agents are considered as acting under the instructions or under direction or control of a state. This would be the way that you would sort of package it into it in Article 8. Or the simplest solution is whenever you sign an AI guiding treaty, you make both states adopt and acknowledge the behavior of their TFI agents as their own, which then sort of passes through Article 11, and it is state behavior. So the final part to discuss here is the question of how would TFI agents go around interpreting the treaty. Traditionally, the Articles 31 to 33 of the Vienna Convention on the Law of Treaties, again, codify the customary international norms and provide this sort of baseline for interpretation. This applies to all states, even the ones that aren't parties to the treaty. So the US, interestingly, are not a state party, but they have recognized the norm very often, and domestic US courts have often referred to the VCLT. And the VCLT, interestingly, again, prescribes how to interpret international treaties, but not who or what is qualified to do interpretation. That does not mean that any interpretation of an AI system carries legal weight for other actors in the same way that like a state interpretation would do, unless you sort of say that like in some indirect way the behavior of the agents, because it's attributable to the state, is a state interpretation. But it does not need to carry legal weight, but it is enough to sort of guide their own behavior. And so the VCLT sort of general rule is that a treaty shall be interpreted in good faith, in accordance with the ordinary meaning, to be given to the terms of a treaty, in the context and in the light of its object and purpose. And nothing really prevents AI agents from applying this methodology. They can reason about what is the ordinary dictionary meaning of a term. They can reason about which interpretation would be more effective given the object and purpose of this treaty, and you can very clearly set out the object and purpose. You can also think about the subsidiary, the additional methodologies and components. You can think about the context, so well, obviously the full treaty text, any other agreements that relate to how it should be implemented. You could think about any subsequent practice in implementing the treaty, or any other rules in international law that clarify questions of interpretation and definition. And then, okay, so I'm going into my sort of final section. You can think about the supplementary means of interpretation. So what was the circumstances of the conclusion of the treaty? There are some challenges here. One is that when it has to access preparatory materials, these are not always available. So there's a legal grounding problem. There's also a corruption challenge. So Deeks and Hollis discuss how there is the risk of LLM grooming attacks, as we've seen with Russia, sort of spreading tens of thousands of fake news articles. This has shifted the behavior and responses of LLMs. And so you could then seed the internet with legal disinformation, and in that way skew TFI interpretation, especially under the sort of state party's track record of applying the treaty. To be fair, this is not really a problem only for TFI agent. It's a problem for all legal use of generative AI, and in fact, for all human international lawyers. If you can no longer, easily trust this information. You cannot trust this information, but if you can no longer, easily trust online reports about state behavior. And there's some challenges over, again, do you get a combinatorial explosion if you have to think about many other areas of international law in interpreting or filling gaps? I'll speed through there are institutional measures you can take to sort of clarify this a bit more. You can have an arbitral body first off, you can specify special meanings for technical terms under the VCLT, and states can agree on that. Or you can designate an authoritative interpreter, such as or a arbitral body like ITLOS under UN Convention on Law of the Sea, and they can interpret these provisions and accumulate jurisprudence that TFI agents could either refer to or extrapolate from further. The benefit of this is that it anchors the treaty in human interpretive judgment. It sort of all bottoms out into human, human judgment, and it allows evolution over time. The challenges of this is that, as with other arbitral bodies, you can get institutional drift, politicization, and member state backlash if they are seen to exceed their mandate, as happened with the WTO appellate body. So this is ultimately a TFI framework, I think, is very promising politically and legally as a means of recovering the functioning and integrity of treaties at a time that these instruments are under a lot of pressure. But there are obviously a lot of uncertainties and questions, and I particularly have a bunch of sort of outstanding questions. So one is, okay, isn't this just booting over the verification challenge from having to verify how people are using or misusing their agent to having to verify that they are, not taking off the TFI training? How you avoid a state from operating one data center with nicely aligned treaty-following agents, and then they have a dark data center that is sort of like having all of the bad boys. How do you apply this to agents deployed by non-state private actors? Is it just implementing regulation, or is it just more like, well, private companies could be inspired by the framework and have sort of like industry standards or industry codes that are also self-executing? If TFI agents aren't normatively duty-bearing, why even bother housing this under international law? You could just have TFI SHMITI, their non-formal standards. The advantage, or is that, well, the implication of this is that you just could have even more bespoke agreements about how you have interpretive flexibility, about how you interpret the text. But the cost here is that you fragment global governance further. And finally, one case about sort of the indefinite or like irreversible benefit sharing agreements. There's a lot of debate over whether you can craft a treaty that does not allow unilateral exit by a state, and the presumption is that you can, if there is no exit clause and it's clear that states didn't intend there to be a right for unilateral exit, then even if a future administration changes their mind, they technically cannot withdraw. And that would mean that the legal agent, even if their state says, well, we have withdrawn, the legal agent would ignore it because it's not valid under international law. But that has a lot of obviously political conflicts. And with that, I unfortunately don't have a lot of time for questions, but I happily take questions afterwards. So thank you very much.